Does the surviving spouse automatically inherit the house and the entire estate? Let's talk about that. My name is Tonya and I'm a real estate agent who specializes in probate. And you would think that if you're married and your spouse dies, that you automatically get the house and you automatically get everything in the estate. I mean, after all, you have a ring on your finger. That makes the most logical sense, right? Well, I'm going to tell you it depends. And it depends on whether or not you took the time that it takes to do some estate planning. And if you didn't take that time, then you're left to the whims of the state law. So let's dive into what it looks like when you didn't plan versus what it looks like if you plan out in the future so you don't fall into any issues down the road where all of a sudden you've inherited a house with somebody you didn't want to inherit the house with. First of all, if you are married and there's no will and you have no kids, the state will say you inherit everything as the spouse. And of course, there's some ways that you can take title that helps make sure that that's the case. But the state will say, yep, you don't have any kids, your spouse is your only heir, and therefore they get the house and the estate. Where this can get tricky is if you don't take titles with joint tenancy with rights of survivorship, because that avoids probate and allows the spouse to inherit the house. But if you're tenants in common, which we see this happen all the time, and your spouse dies, there's no will, then you own half of the property. Your spouse owns the other half. And when they pass away, you get a portion of that house and your kids get the rest. And the way the state has it set up is the spouse can get no less than 1/3 of the estate. So if you have one kid, you're splitting that estate and house 50-50. And if you have more than one kid, they're splitting it 2/3 and you only get 1/3. So all of a sudden you could own a house with your children. And it gets really bad if your children are minors, because if they're minors, then the court is going to put a guardian for them, because then you just can't sell the house because they got to protect their interest, even though you might be their mama or their daddy and think you know what's best for your child. So you can see how this can get super sticky quick. The other thing that can get messy is if you have a blended family. Like, let's say that you and your spouse have married, but you have children from previous marriages. So you might have some stepchildren, and if your spouse were to pass away and you didn't have a will or any kind of title set up appropriately, then you could inherit, theoretically, the house with your stepchildren. So let's talk about how we can kind of prevent some of these things and get some things in place to make sure you don't have this headache, because it is a huge headache. I've seen it happen to more than one family where they just didn't have things laid out. And then you have to go through a bunch of hoops to get things fixed. And God forbid people don't start getting along, because then that makes it even worse. First up, let's talk about deeds. Tenants in common can be split any different way amongst people who own that property. So somebody could own 1/3 of the property and somebody could own 2/3 and it be tenants in common. But how I see when married couples take title, if they take it with tenants in common, it's usually 50-50. But if there's nothing in place, no will that says that 50% goes to you, then it goes to that person's heirs. And the way the Georgia law says the heirs is if you have children, then portion of it's going to go to the children. The one way to fix that is with joint tenancy rights of survivorship. That allows you to be married, and if one of you were to pass away, then the surviving spouse gets the house and nobody else does. It's kind of like the last man or woman standing with the joint tenancy with rights of survivorship. So whoever is alive last gets the house. It's very easy to switch from tenants in common to the joint tenancy with rights of survivorship. I know some closing attorneys around here that might do it for a couple of $100. Easy peasy, you get it fixed, everybody signs it. That's one layer of protection. Now for spouses, I probably would not pull out the transfer upon death deed, but unless there was some reason or another that you didn't want to have your spouse originally on title, because you should be able to add your spouse on title relatively easy. But if you only had one spouse on title, and you could do a transfer upon death deed to where you name a beneficiary and that person would inherit it, right? So it could be the spouse, it could be children, it could be whoever. The problem with that one is that the beneficiary has 9 months after the person dies. If they don't, and it's 9 months and a day, the thing is going through probate. So sometimes people will use a transfer upon death deed for their children to avoid probate. That's one way of doing it. Talk to an attorney about it, because the way the law is written around that deed is very loose, and if you do not follow everything to the T, it could cause trouble later down the line. The next layer of protection is going to be a will. And most attorneys aren't going to charge you an arm and a leg to do a will. And that's simply a will is going to state what that person's wishes was. And, they're going to name an executor. Most likely it's the spouse. Sometimes it's not. It depends on, whether the age of the person, if the person's older and they just want their kids to handle it. Sometimes they name the executor as one of the children, even if the spouse is still alive. But that thing will direct what goes to whom. And, if you have that blended family thing, you might want part of your house to go to your children. You might have an insurance policy that would kick in so that, the spouse could buy out the children and make the children whole. There's all kinds of little planning things you can do around that. That's when you can get with a good financial advisor, get with a good estate planning attorney to kind of help you navigate that if you have that blended family. Otherwise, a will, even if you don't have title correct, even if you have that tenants in common, a will can say that the house goes to the spouse and it will override any kind of state law. The downsides to a will is it has to be original, so you cannot bring a copy into the probate court. That will be unaccepted. If you can't find the original, then it's going to go back into those state laws, and that could be troublesome. Also, do have a will and somebody isn't happy about how the will is written. Let's say they were written out of the will for one reason or another. They could come in and contest it even though it's going through the probate process, and put the probate process to a grinding halt, just to a grinding halt until all of that mess is sorted out. Now let's get into the ultimate protection. And this is a little costly. It is. I'm going to say a basic trust roughly runs around $5,000. And that's a rough number. Don't hold me to it. Call your planning attorneys, your estate planning attorneys, and see how much they charge for it. And the more complex the estate, the more money it's going to cost. But to get a basic one down, it avoids probate entirely. You can have a will that runs alongside of it. The trustee can act immediately after someone passes away. And depending on who the trustee is, they can even act while the person's alive. So let's say the person has memory problems or whatever, and they name their child as a trustee. The trustee can sell a house while that person's alive. They can act relatively easy on behalf of the person who has the trust. And of course, like I said, after they pass away, they can act immediately. The trust can be sued. It absolutely can be. It doesn't stop the trustee from doing their job, which means that if they need to sell the house for some reason or another right after that person died, because maybe they need the equity out of the house, they need that money, then they can go and do it. Easy peasy. They don't have to get permission from the court. They don't have to get letters of testamentary or letters of administration. They can just go act because they have that paper that says they are the trustee that can act on behalf of the estate. It keeps it out of probate court entirely, and it kind of keeps things private. I mean, probate court's very public. You have to list the assets out, whether it's how much the house is worth, how much all the money assets, and I don't know about you, but I have seen people go bonkers when somebody dies and then all of a sudden there's money involved. People we wouldn't think act ugly. All of a sudden money's involved and the ugliness comes out. Having that trust can there might be ugliness going on, but it does not keep that trustee from doing the job, which can make things go way smoother. So there may be a lot of cost on the front end, but I guarantee you, if people are fighting on the back end of this thing, whether there's a will or not, It can cost well over $5,000 to get an attorney who's going to litigate on the estate's behalf and on the administrator or the executor's behalf. It could get ugly fast. I've seen things get up into the thousands, double digit, trying to fight somebody who is causing trouble unnecessarily, mind you, causing trouble nonetheless. If you're a surviving spouse and you're like, oh my goodness, I do not know up from down, left to right, because I mean, it's overwhelming. You're grieving. You just lost your spouse, your loved one. Maybe you don't know what your spouse did in estate planning and you're just overwhelmed. Take a breath. If you need a good attorney, I can get you in touch with one. Let me know. And I do have a probate timeline so that you can download that. Link will be below. So that you can kind of get an idea of the flow of the steps, because being an administrator or an executor is not for the faint of heart. And if you're a trustee and you need help, I can help you too. But at any rate, I hope you found this helpful and you kind of understand what category you might fit in. And let me know if you need help selling a house or need any resources. I'm here for you. Stick around for other videos like this, and I'll see you later. Bye.